I'd like to start with saying it's been an extremely interesting first year for the division, to say the very least, and I welcome the opportunity to provide you all today with an update of how things are progressing in that regard. I will start with a passing reference to the recent review which was published by Deloitte, which included the perceptions from compliance professionals in the industry in Guernsey on how they saw that things were developing in the enforcement arena. On the whole, I agree with the comments that were made, especially the comment that it would take some time to get into full swing. It may seem that things have been moving slowly in some areas, but I can assure you that the division has been and is extremely busy. We have had a mixture of old legacy cases to work upon and also have taken on a mixture of cases to do with AML, conduct and corporate governance. In essence, we are about helping maintain the confidence in the bailiwick by keeping markets clean and ensuring that wrongdoing is sanctioned appropriately. In effect, we wish to make sure that the good firms that do the right thing are not disadvantaged by those that are not. In doing just that, licensees can expect to be dealt with by a professional enforcement division striving to protect all that is good within our industry. Last year, as you will probably recall, with the enforcement division being in its infancy, I set out the structure and how we propose to investigate matters in a transparent, proportionate and fair manner. I also walked through the main points of the decision-making process and described the process that a licensee or individual can find themselves engaged in when dealing with either the enforcement division or a supervisory division. On the whole, the structure of the enforcement division has not changed. However, a recent addition is that of Advocate Liam Roffey, who will be assisting the enforcement and financial crime divisions. Liam is already proving to be a considerable asset to the Commission, as he comes with the title of ex-Crown Prosecutor and also with private practice experience as a defence lawyer. Having only been with us for a very short time, he felt the need for a well-deserved holiday and has just embarked on a pre-booked holiday to South America. Unfortunately for Liam, he thinks he will be back in the office at the beginning of December, but I still have some contacts with my old colleagues at Heathrow Airport, and I'm suggesting that that Liam may be with us back slightly later than he expects. For the criminal lawyers and law enforcement officers, both current and ex, you'll understand what I mean by that. The move to employ a lawyer was felt necessary due to the number of cases and the complex legal issues arising out of them. And it will reduce the Commission's legal costs, which have until now generally been outsourced. Recently, we have also been receiving considerable support from HM Procurers Chambers, specifically from the civil litigation team, and in particular, I think it's correct for me to mention today, Crown Advocate Jason Hill. Some level of ongoing support from Chambers will still be required from time to time, which I'm truly grateful for. So what has happened in the first year? If any of you are in the unfortunate position of having to listen to me last year, I kept reiterating the processes which we wished to adopt and the fact that we wanted the way we dealt with enforcement matters to be open, transparent, reasonable and fair. Nothing has changed in that regard, albeit at times some of the correspondence we've received over the last year would suggest otherwise. It is, of course, accepted that we are going to face considerable legal challenge on the majority of what we do. However, I remain hopeful that by ensuring we adopt a professional approach in all that we do, we can encourage all parties to consider sitting down with us and negotiate sensible outcomes. In adopting such an approach, I and my division are acutely conscious of the need to demonstrate a fair and transparent approach, and we will do just that. We will ensure that we place the facts and supporting evidence before licensees and individuals and their representatives and ensure that they are afforded the maximum opportunity to make representations on the findings and to put over their side of the story. As I said last year, we accept that such an approach will not always be possible, and on several cases that are going the full distance, for want of a better phrase, I will say more shortly about the mechanism for dealing with these matters before a senior decision maker. We also accept that on occasion we are not always going to be right about our initial findings. If you believe we have it wrong, I would encourage you not to just go down the route of protracted correspondence telling us how bad and unreasonable we are, but instead provide us with the material to show us why and how you think we have got it wrong. Better still, come in and discuss matters with us, and I assure you that we will review it and listen to what you have to say, as surely this approach has got to be in the best interest of all concerned. If the opportunity to come and speak to us is not taken, for whatever reason, then the whole process will become lengthy, the interpretation of documents provided by a licensee could be misunderstood by us, and whereby any fears we had could have been dispelled at a very early stage. Having said that, we have found in this year that on occasion it is simply proved impossible to have sensible, meaningful conversations with some licensees and individuals and their legal counsel. And we are therefore faced with no alternative but to move forward with what we believe to be the findings of our investigation, and if necessary, refer the matter to a senior decision maker for consideration. Sadly, in such cases, much time is taken and costs incurred by both the Commission and the licensee, with protracted correspondence from legal representatives in an attempt to derail the investigation. This approach is completely counterproductive, and the Commission will robustly defend its position. In some respects, I take some comfort when this happens, because if the process is being attacked, then the licensee and their legal representatives potentially have issues concerning the findings. Clearly, how a licensee chooses to defend themselves is a matter entirely for them. However, I would simply encourage everyone to at least consider that there is an alternative way forward based upon common sense and an understanding that until the Commission has been provided with sufficient material to show that we have got things wrong, we will move forward with our case based on the evidence before us. I have to give a strong message here, in that if we believe that serious breaches of the regulatory laws have taken place, unreasonable argument will be strongly fought by the Commission. And we will investigate the matter thoroughly with or without the cooperation of the licensee. I do not want that to happen, or this message to come across in threatening in any way, but nevertheless I have to be clear in our intentions that poor behaviour and conduct within the industry will be properly investigated. My role is to ensure that we do this within our legal powers and in a professional and open manner. In my first slide, I mentioned the addition of Advocate Liam Roffey to the Commission, and he will take forward our cases before the senior decision maker or the Court of Appeal, if necessary and appropriate to do so. Right. After that particularly gloomy statement, I have to say that in most of the investigations to date, licensees have cooperated fully with the requests made of them, which naturally makes the process quicker and on some occasions has enabled initial concerns to be constructively addressed and re-evaluated. Remember this, the Enforcement Division is investigating a matter to try and establish the facts. This is as a result of a Supervisory Division being concerned about aspects of the conduct of their licensee. All of the cases investigated to date have been brought to a successful conclusion in favour of the Commission, whether by agreed settlement or via a senior decision maker, which again gives me some comfort in that what has been referred to us by supervisory divisions and then subsequently investigated has been shown to be based on correct analysis and solid evidence. It also shows that the internal process with our case review panel, which is referred to within the guidance document that's on our website, is working properly. However, I can assure you that the case review panels, which is the internal panel chaired ordinarily by the Director General, is always proved to be challenging for my division. And we always face tough questioning regarding our findings. This is to be expected and is also welcomed by me, as the focus has to be on ensuring our findings and evidence are robust and can withstand any scrutiny. This ensures that we are not engaging with a licensee or individual with weak facts that could or should be dealt with by way of supervision or by other means. It is of note and is to be commended that on 5 occasions we have reached early settlement with licensees, and this was taken into consideration when setting the sanctions to be imposed. In 4 of those cases, they involved AML breaches of varying degrees. If I go all the way back to this time last year, I had absolutely no idea how many cases or what the nature of those cases would be that would be referred for investigation by my colleagues. But since November last year, we have brought 5 cases to a conclusion, and we currently have 3 further cases before a senior decision maker for consideration, one of which has had its oral hearing last week. At least 3 other cases are in the pipeline to be referred to the Division for Investigation also. Although there are signs of a healthy turnaround of some of the cases, we are still striving to improve in all areas of how we operate and ensure that cases are progressed as expeditiously as possible, bearing in mind that the approach and pace of progress is often in the hands of those that are being investigated. During the course of our investigations to date, the Division has also sought evidence from our international colleagues, and in that regard we have reached out to the likes of Mauritius, the UK, Gibraltar, the United States, South Africa, and not forgetting our colleagues across the water in Jersey. Having said everything I did on that last slide, it is worth just bringing some context to this. And I would just like to take a moment to remind everybody of Article 10 of the Principles of Conduct of Finance Business in this regard, which is that a financial institution should deal with the Commission in an open and cooperative manner and keep the Commission promptly informed of anything concerning the financial institution which might reasonably be expected to be disclosed to it. Parties are required to help not only the Commission but also any decision maker if a matter is referred for consideration. Therefore, this is something that would be expected from you. So moving on, what has changed? After careful consideration, we published in March 2014 our guidance document on the decision-making process. This document goes into far more detail than previous documents, which is in line with our commitments to be as open as transparent as we can be when dealing with a licensee. In effect, this will be the process that licensees can expect to be involved in if a matter is referred for investigation. I talked last year about dealing with matters in a just manner, including, so far as practical, ensuring that the parties are on an equal footing and dealing with the matter in ways which are proportionate to the likes of the amount of money involved, the importance of the matter, and the complexity of the issues. As I also stated last year, we are to have a particular focus on the protection of investors, and this has not changed in that regard. As the year progressed, it became clear that some additional clarification would be helpful on the decision-making process, as there has been confusion, or dare I say, some lengthy and unnecessary legal challenge over disclosure of material. Therefore, in September this year, the guidance document was amended to show the difference between provision of material, which the Enforcement Division wishes to rely upon as evidence before a decision maker, and disclosure of relevant material, which we do not intend to use, but we believe to be relevant material to be provided to a licensee or individual. I must emphasise that we are working to an administrative process and not that of the civil court. However, we try to ensure that processes are robust and are appropriate and reasonable to all parties. The Commission is not trying to confuse or mislead anybody, but merely attempting to adopt a fair and reasonable process regarding disclosure. When establishing the facts of our case, as I have said on many instances, there may be a good reason why a particular event has occurred, and if so, what we require is that you produce material to that effect and explain it to us in an open and transparent manner. Another area we wanted to change within the decision-making process was the settlement process, and to highlight exactly what discount licensees and individuals could expect to receive in the event that they wish to settle on agreed terms with the Commission. So there is very good reason to come forward and discuss matters with us if you know the failings identified are right. Because if you settle on agreed terms, the penalties can be reduced considerably. Now, I've mentioned the senior decision maker. And if I can turn to that now. Earlier this year, the Commissioners delegated to the Commission Secretary, Dale Holmes, the power under Section 11 of the FSC law to appoint senior decision makers as officers of the Commission. This situation will occur when an enforcement case has been investigated and evidential material to be relied upon has been presented to the licensee or individual. Once representations have been received from the licensee or individual and any amendments to the enforcement report have been made, the final report and supporting evidence will be provided to all the parties concerned. If the parties do not wish to enter into settlement negotiations on a without prejudice basis, we will refer the matter to the Commission Secretary with a request to appoint a senior decision maker. Once this stage has occurred, all parties, including the Enforcement Division, will await a decision or instruction from the senior decision maker on his or her findings. As has happened in some instances this year, requests for further information are made by the decision makers. These instances will occur where there is no realistic prospect of settlement between the parties, or if the Enforcement Division is of the view that the only way that this matter should and can be dealt with is before a senior decision maker. To go on a little bit further, we recently published the names of those Queen's Counsel who have been appointed to the Commission's panel of senior decision makers and who will consider enforcement cases. They will sit as a single judicial officer and consider the material that has been provided to them. This will be the material that has been provided to the licensee or individual, as I just explained. In one case earlier this year, the senior decision maker made many requests for more documents from the Commission that were also made available to all the parties under investigation. This was welcomed by the Enforcement Division, as it showed that careful, well thought out consideration was being given to all aspects of the case. The panel members clearly have the requisite skills to consider the issues placed before them, and they are completely independent. This new approach will also ensure that the hearings are dealt with in accordance with best practice, and that any legal issues that may be brought by parties' legal counsel can be properly and professionally dealt with at the time. And to ensure that the process is smooth and, most importantly, fair to all concerned. It is early days yet, but I honestly believe that we will all learn from this new approach. And I accept that there are going to be occasions when the Commission receives a bumpy ride as a result of a case we ask for judgment on. That is inevitable. If we get it wrong or misinterpret material obtained during the investigation. However, I sincerely hope that due to the internal processes with our case review panels that we operate, that these occasions will be few and far between. If they are too frequent, then I'm pretty sure that Case and William will be looking very closely at what I am doing. If I may, I'd like to point out one common issue that has arisen during the course of investigations in the last year, and that is the outsourcing of functions, whether compliance or otherwise. If I may take a note from Susan Grossi, who I know a lot of you in the compliance arena will know due to all the tremendous training work she does over here in Guernsey. And I did ask for permission if I could use this comment today. You can give away the task but not the responsibility. It's a bit like trusting someone else to do up your seatbelt for you when both you and he know that if there is a crash, it will be you catapulting through the windscreen while he stands on the hard shoulder. It's a bold statement, it's to the point, but in essence it's true. The Commission has recently placed information on the website regarding the outsourcing of functions and the fact that the responsibility remains with the licensee. I cannot emphasise enough that licensees who try and lay blame on the firm that they have outsourced any of their functions to, that this will not be accepted as a form of defence by the Commission. Licensees must take up the responsibility, and too often during the first year of our existence, we have listened to firms say that they have paid a lot of money to outsource a particular function, and it is not their fault that it has gone wrong. This is not accepted. So please, please look at the reports that are provided to you by those that you've outsourced to. Challenge them where necessary, and where concerns are raised, deal with them as early as possible. In some instances, the firm completing the task has been highlighting serious issues to the senior management and the boards, only for those concerns to be completely ignored. And if I can very quickly refer you to the handbook and sections 27 and 28 in that regard, which make it absolutely clear on where the responsibility remains with that in mind. I really don't think I need to say anything more on this issue. And finally from me today, just a reminder to all of you that we have a whistleblower line that is managed by the Intelligence Division at the Commission headed by Kevin Bown, who late last night told me that he considers himself to be a shadow warrior, whatever that means. All of you here who know Kevin know what his sense of humour is like, so I will leave that to your imagination, as mine will completely run away with it. So this line is totally confidential, and information is dealt with on that basis by the Intelligence Division. I would also add that there are plans afoot to set up a generic email address to receive information to. The details will be announced in due course, I'm sure, by Kevin. And Kevin has also asked me if I can just remind people that if you ever wish to talk to him or his colleague Mike Savage in person, they are willing to listen to what you have to say. That is all from me today, and thank you very much for listening.